Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. If I can help you in any way, that's what I'm here for today. Host of Ask an Attorney, all about Florida law for over 34 years. The main purpose of the show is to come in and help as many people as I possibly can. So if you have a legal question or just a problem that you'd like to discuss, looking for a way out of it, looking for some information, we have a toll-free number. It's 877-943-9673. That's 877-943-9673. Hey, your question can be about wills, trust, probate, guardianship, power of attorneys, family law, real estate law, personal injury, just about any area of law, or just if you have a problem. We're here to help folks. And a lot of times common sense applies to problems as well as legal information. So, hey, if it's something I can do for you, give us a call. You have 877-943-9673, and our phone lines are open. We host this program on many stations around Florida, broadcasting today from Tampa. And in the Salem family of stations, we have 570, 910, 102.5, 860, 930. We have stations in Haines City, Florida, Central Florida, WLVF, 90.3 FM. We have the community station in Sun City Center, carries the program. We have a radio station in Crystal River that carries the program. We have, and we have in Zephyrhills, Pasco, Trinity area with also radio shows. So if you have a legal question, all you have to do again is call 877-943-9673. Let's go to Jay calling from St. Petersburg.
Yeah, Mr. Pippen, I spoke with you probably 3 months back, and we were discussing setting up an estate, and your advice I understood pretty clearly, and I understand probably the benefits of a trust as compared to just allowing everything to be, like in my situation, operation by law. But I did have a question about, I'm getting up in age here, and I every time I see someone settle an estate, they have chosen someone, whether it's an executor or our personal representative or a trustee.
Right.
And my question is it advisable to choose a law firm to be successor in case, because what I see is sometimes family members, they're very competent people, very educated people, they're either afraid or they just don't want to do it. And so is it wise to set up an attorney to step in if they don't want to serve?
Yeah, well, I think it's always good to have a contingent trustee named. You have a primary, a number 1, 2, sometimes a number 3. So if the first one can't do it or doesn't want to do it, is too ill or sick or just not able or interested in doing it, they can resign down to the second person. Now, lots of families will name family members, as first and second choice.
Right.
Some people will name a family member first choice and either a corporate trustee or an attorney in position of backup. Some people will name 1 or 2 family members in the corporate trustee or law firm or accountant or CPA, so forth, whatever professional they trust to be able to do it, in third position. So you always have contingencies in these spots. And also the first person that's chosen, if they don't really want to do it, they can have complete guidance from the attorney.
Okay.
You can have an attorney coach, so to speak, to coach them through the whole process. So, every family is a little bit different, and those are most of the choices that are available.
I understand there's a cost associated with an attorney handling probate. I'm assuming, in fact, I know you don't work for free. So how do you contrast or compare the cost of an attorney handling a probate issue where there's probatable assets as compared to an attorney handling a trust where the trust has been properly funded?
All right, well, probate, there's no probate necessary if everything is properly put in a trust, but I'll go over both sets of fees. The state of Florida has a recommended statutory fee for the personal representative and the attorney. And there's a scale, but let's just say the average fee is 3% on most estates. So the attorney can make 3%, the personal representative can make 3%. Sometimes if the attorney's in both positions, the attorney is the personal representative and also the attorney handling the estate, the fees can be 3 and 3, or sometimes the attorney will reduce the fee somewhat in that situation.
Okay.
The typical trustee fee, now most corporate trustees have a scale they publish of fees, but the typical fee I would say is around 1%. So the attorney or the corporate trustee would probably charge in that range of fees.
Okay.
And that depends on how much money there is usually that's in the estate or in the trust.
Righty. I guess one last question, if you have time.
Sure.
The person that I would probably select would be my son, and he's a very competent person, has a great degree and all that, but he lives in Georgia. Is that...
No, that's not a problem.
Not a problem.
And your son could certainly use an attorney to do certain things or advise him how to handle matters within the trust, so he could be coached by an attorney very easily, and he could do the job probably.
Okay. All righty. Well, I really appreciate the information.
My pleasure. Thanks for calling.
Thank you, sir. Bye-bye.
Phone lines are open if you have a legal question. If I can help you in any way, 877-943-9673. That's 877-943-9673. Phone lines are open. You're listening to Ask an Attorney, all about Florida law. If you have a legal question, give us a call. Let's go to Kurt in Seminole.
Hello, how are you?
Good, and you?
Pretty good. Quick question. Father passed beginning of this year in March, and we have, I guess, basically his first family of 3 and his second family of 3, and he had a trust set up, and the two trustees are from the first family.
Mm-hmm.
And the business building that he had is intended to be sold and put into the trust. And what I'm curious about is, since we are not in control of any of the trust, is it mandatory that if it's dictated by him, that those monies from the sale of the building go into that trust account?
Well, was the property in the trust to start with? I mean, was the property deeded from himself?
It was dictated that the property be sold and divided by 6 evenly throughout all of his kids.
Okay, but do you know the answer to the question, and was the property in the trust, name of the trust when he died, or did the will leave it to the trust?
I believe it was in the trust.
Okay. Well, the answer is the trustee has to do exactly what the trust says. So if the trust says to everything that's in the trust shall be divided in 6 equal shares, the trustee's job in this case would probably be to sell the property and divide the money up in 6 equal shares. He can't deviate from do what they want to do. They have to follow the instructions of the trust.
Okay. I just heard in a couple of places or from other people that they didn't necessarily have to put the funds directly into a trust account if there was some finagling they could do.
Well, if the property is deeded to the trust, the closing agent will issue the check to the trust.
Okay.
So I mean,
right.
So if the property was in his name and not in the trust, then it would have to go through probate. And assuming that he had a will called a pour-over will that left everything to the trust, the proceeds would still wind up in the trust.
Okay.
So,
alrighty. I wish I had a little bit more information to nail that down, but I appreciate your help. And time.
Well, listen, here's the thing. You are entitled to an accounting of what's going on in the trust.
Okay.
So if you've not received an accounting, you can't get one, you can have an attorney write a demand letter that you have a proper accounting.
Okay, great.
So that would be...
Alrighty.
All right.
Yep, thank you, sir.
Thank you.
Take care.
All right, let's go to Terry in Sarasota.
Yeah, good morning. I have a friend that passed away March of 2017, and she had a car, a Lexus. Well, she had a daughter that was out of state that wasn't taking care of anything. So I sold the car for $3,100. But the gal that bought it never picked it up, and I couldn't get a hold of her. And now she's wanting $2,900 back. Other than morally, am I required to give her money back? Is there a time limit?
Was there a written contract? Was there a bill of sale?
Well, I did write her a little note saying that she gave me $3,100 for the car. You know, just a little scribbly note. So that
there probably should have been a bill of sale, like a contract to purchase the car as is. You would normally do.
Yeah.
So
I just put receipt and so for payment of such and such and the VIN number, and I signed it. And yeah, she signed it. But.
So why did she say she didn't want the car now?
Well, I just got a text from her son saying that she was in an accident, and I guess she's disabled. So, you know, just morally, I feel like I should probably do it. But I don't even have the money. I sent it to this lady's daughter.
Well, when you got the money,
yeah,
did you sign the title over to her and give it to her?
No.
Well.
No,
So what? Who do you still have the title?
Well, I resold it then. She bought it from me. I couldn't get a hold of her. No way. I texted her. I called her. I did everything, and I couldn't get a hold of her. And I didn't want this car, and so I sold it to somebody else.
Well, how much did you get for the second sale?
Just $2,200. And I sent it all to her daughter.
Okay, well, so you kept the money from the first sale and didn't give her the title, and then you sold it to someone else and kept the money for the second sale.
True.
Well, I think you have a little problem there. I think, you know, you can't, if you're going to sell it to someone else, you should have given her a refund.
But I couldn't get a hold of her.
You should have probably given the money to an attorney just to hold an escrow, or set it aside somehow and kept it separate. Now, keeping it would probably, if this thing went to court, I think you'd be in trouble. I think you would be in trouble because you kept the money and sold it to someone else.
Yeah. So I should probably give it back to her and if she's disabled, I really do feel bad for her. I don't know if that's true or not. She's up in Minnesota supposedly, from what the text says, and I don't even know if the text, if it's legitimate or if it's a hoax. But I guess it's true.
Yeah, well, you should feel sorry for her, regardless if she was disabled in this case, because she gave you money and didn't get anything for it, and then it was sold to someone else. So.
Yeah, but I mean, she didn't pick it up.
Yeah.
I couldn't find her.
Yep, I understand.
So,
well, next time when you do something, when you sell something major, you should have an attorney, because see, there should have been an as-is contract with the mileage, and she had had a hard time even taking the title. The title would have had to been properly filled out, and the minute she gave you the money, you should have signed the title and given it to her, or even taken the title with her to Division of Motor Vehicles, so you have an official transfer.
She didn't have time at the time, and I tried to make arrangements to go to the vehicle department with me, because I didn't want to give her the title without seeing her sign it over, or, you know, I wanted to go with her. And anyway, okay, I'll see if I can get the money from her daughter. I know I can't, but I'll just, you know, sometimes you just pay. So, okay.
All right, well, sorry for your problems. All right.
Thank you.
Thank you. Phone number, if you have a legal question or a legal situation or something you just need to talk to an attorney about, doesn't even have to be a legal issue. Love to help you if I possibly can. You have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. Let's go to Pam in Venice.
Hi.
Hey, Pam.
Good morning.
Good morning.
Yeah, so my question is about Medicaid asset protection.
Mm-hmm.
I've been reading about these trusts that can be set up to protect your assets, and from the research I've done, it's not clear to me exactly what assets are exempt from this kind of agreement.
All right. So you're talking about creating a trust for yourself?
My husband and me, yes.
All right. And how old are you?
I'm 67 and he's 72.
And are there health issues to be concerned about at this point?
No, not at this time. I guess I'm the one that's a little worried because I have Alzheimer's in my family medical history. So I wouldn't want to see a scenario where, I'm in a nursing home and all of our savings and assets are going to my care. So that's kind of where it was coming from.
All right. Well, actually, I've co-authored a book with one of my attorneys on Medicaid and asset protection planning.
Ooh, okay.
So if anyone's interested in that, the book is $20, and I'd be glad to, if you want to order one, that would be fine. But let me answer your question. You could create a trust, but when you could create an irrevocable trust, which most clients don't do, to be upfront with you.
Yeah.
Because then you've restricted yourself on what you can do with the assets in the trust. But you can create an irrevocable trust, and there's a 5-year look-back period right now on qualifying, making gifts and qualifying for Medicaid. So creating an irrevocable trust and putting assets in it is a gift to the trust that you can't basically get back, although you can derive some use of the money in the trust, like for income only, and so forth. But there's a 5-year look-back period. So you create an irrevocable trust today, put your assets in it. There's a 5 years from now, you go in a nursing home. Hope you don't, because you'd still be pretty young. But so the assets, with those assets in that trust, would be non-countable. So if you had enough in there to be non-countable, you could qualify for Medicaid. However, most of our clients your age would just do a durable power of attorney. And in that durable power of attorney, you have powers that you have to initial off on that grant powers to be able to move assets around to make them non-exempt, so you qualify for Medicaid. And most of the time, our Medicaid attorney can move everything around within about 60 days and protect most of the assets without creating an irrevocable trust. Irrevocable trust is one of the planning options, but people don't like it too much because they restrict themselves of their assets. Now, if you're 92 and pretty healthy and think you're going to be healthy 5 years from now, you might want to create an irrevocable trust, put your assets in there, and when you go into the nursing home at 97, you would qualify because you put your assets effectively in a trust 5 years ago. Right. So what you need to do probably is you and your husband sit down with an elder law Medicaid attorney and go through all of these options that you have, and then just make a decision moving forward.
Okay, so if we didn't go through a trust and just, let things roll along, I understand that your house is
yeah, your house is exempt.
And a car.
Car's exempt. For the community spouse, the house would be exempt. And even if you both went in a nursing home, the house would still be exempt. But if you went in a nursing home and your husband was in the community, he could keep the house, the car, and up to close to $130,000 of other assets, and you would still qualify. And if y'all had more than $120,000 to $130,000, then the rest of that could be moved with using this power of attorney into exempt, non-countable assets.
Okay.
So,
and the other specific question I had was about IRAs and rollover Roths.
Yeah, those are countable.
Nope. Those are countable.
Yeah, pretty much everything's countable, except for the house and the car and the community spouse provisions, which is $125,000 to $30,000.
Okay. All right. Well, I'm definitely interested in reading your books.
All right. Well, you could just send a check for, or you can call and order it. We have a toll-free office number, 1-800-226-3529. That'd probably be the best way to do it. You can just give them a credit card and they'll get it right out to you.
Okay. Very good. Thank you
so
much.
Thank you. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, do you have a question I can help you with? Do you have a problem I can help you with? Doesn't even have to be a legal question. It can be just a problem type of situation that you have. Would love to help you. And all you have to do is to call our toll-free radio number here is 877-943-9673. Hey, today we're also broadcasting live on Facebook, live there through, and you also can catch the video live production of the show on webeamtv.com. So either one of those will be our video feature of what's going on today. And the radio stations all over the state of Florida carry Ask an Attorney, all about Florida law. We're on about 12 stations around Florida. And it's every Saturday morning from 8 to 8:52. Actually, it's 8:02 to 8:52. We have 50 minutes of straight run, no commercials. I don't know if you've ever noticed or thought about that before. We're commercial free. I don't do radio shows with commercials. So we do a 52-minute. There's really no advertising on the show. So we do just here to help as many people as we possibly can. Let's go to Daniel in Sarasota. Hey, Daniel.
Good morning.
What can we do for you, sir? Yes, sir.
Good morning, Joe. Yeah, how are you this morning?
Good.
Good. I have a question to you. Not great news, but about almost 2 years ago, my ex-wife passed away. And, we were very close, no animosity at all. And my daughter said, Dad, why don't you see if you can get her Social Security? So what do I do in a case like that? I mean, should I see if she made more money than I did, not being greedy, but this is what my daughter told me to do. So I thought I'd call you.
Okay, so she made more money than you and had a higher Social Security payment than you did.
Well, see, I don't know. I know her father left about $3 or $4 million, but I don't know about the Social Security part of it,
Well,
I need it. Yeah.
What I would do is call and make a phone appointment with Social Security.
Okay,
have her death certificate, Social Security number in front of you while you're having this conversation.
Mm-hmm.
And tell them you want to check out if there are any benefits you could get from your deceased wife. And if she was making more Social Security than you did, you're probably entitled to a bump up.
Really? Okay. Is there a certain limitation on that, Joe? Or is it like, it'll be 2 years in May, unfortunately. So I loved it. She was like, I just can't believe it. 70 years old like that. But anyway, is there like 2 years you have to get back? Or
I would do it. I would do it. I wouldn't put it off any longer. I would do it next week. I don't think there's a statute of limitations on making that claim. I'm not sure you'll get any back money from it, but you might. But I would call Social Security next week and get online. Get on the phone line with him and have a phone. If you can't get right through, see if you can make a phone appointment, or even stop by the local office with her death certificate and see if you can meet with somebody to discuss that. So it definitely is money there on the table. I think that you'd probably be entitled to.
Yeah. Okay. Well, you're an asset to what you're doing today, Joe. And I wish you and your family a happy holiday and a Merry Christmas.
Merry Christmas to you, sir. Thank you very much.
You're welcome. Bye now.
All right, you're listening to Ask an Attorney, all about Florida law. We're about halfway through the show now. So if you have a legal question, don't delay. Give us a call. We'd love to help you. And by the way, there are other people, when you call in, you don't have to use your right name if you don't want to. It doesn't matter to me. Your question, though, helps other people. That's the point of the show. It's a live show. I never know when I'm going to be asked. I do the very best I can with an answer. If I definitely don't know the answer, hey, I fess up right away because I don't know everything. But I've done the show for 34 years. I've been asked tons of questions, all kinds of different questions. I've had other attorney guests on the show who help me answer some of the questions once in a while. So there's probably not too much you could ask me I don't have some experience with. And I'd love to share that experience and help get you pointed in the right direction, give you a little peace of mind. I have people, I also do a show on every other weekend at 6 o'clock in the morning. And one of the people always ask me, well, who calls an attorney on a live show at 6 o'clock in the morning? And my answer is someone that's been up all night worried about some legal issue. But if you have a legal issue you would like to maybe have a little peace of mind on, or have an answer, or have some direction, phone lines are open. You have a toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open, and I am here to help as many people as I possibly can, just to answer legal questions and help you in any way I possibly can. If you would like, we have several little books that are for sale. We have an estate planning handbook, a Florida estate planning handbook, and we have a Medicaid asset protection Florida book. So if you would like those books, they are, let's say, 2 for $25. I hadn't really thought about this till I had that question today. So if you would like to get those 2 books, 2 for $25, we can give you the toll-free office number, 1-800-226-3529. That's 1-800-226-3529. You can email me that you want the books, and then give me your phone number. I'll have my staff call you. So that email is Joe, J-O-E, at ATTYPIP.com. So that's Joe at ATTYPIP.com. Let's go to Julie in Riverview. Hey, Julie.
Hello.
Yes, what can I do for you?
Yes. I have a question. My husband, his ex-wife, signed the divorce papers, and it's been a long time already. We had an attorney and everything, and the judge wouldn't even hear our side of the story. And he's paying like $600 and something a month for one child.
How old is the child now?
Excuse me?
How old is the child now?
She is 12.
Okay.
But because she put an amount on the divorce paper, and he didn't even sign that particular divorce paper because his English is very off. So he doesn't even read English. So it's like he just like, okay, whatever, because he didn't even get the documents in the mail. She gave it to him the day of the hearing that it was set for the court. We got an attorney and everything on it later on, because whenever we were paying her $200 a month because that was a verbal agreement they had, and then she just waited for those 3-year period to like stop, and she took him to child support and demanded the $600 a month of child support that was on the divorce decree.
Have you discussed
and he
this?
didn't even sign that divorce decree. When I looked through it and read it, his signature is not on that divorce decree.
All right, but there was
his signature.
Okay, but the judge signed a divorce decree or order, right?
Yeah.
And there were certain things that he had to do in this decree, right?
Like I said, my husband's English is really off, so he's like, yeah, so he could just get divorced.
All right, so I'm sure the judge signed what he was required to do, and that's a court order. So you still have this attorney that y'all used?
I don't even talk to him anymore because I felt that it was just we spend money and nothing got done.
All right. Well, you probably need to find an attorney that you know and trust and that you like and compatible with us, can get the job done for you. And it's probably going to need an attorney that speaks Spanish as well as English. You're probably going to need an attorney that your husband can communicate with.
Yes. Well, this attorney speaks Spanish. That's the whole thing. I didn't understand why he couldn't get anything accomplished. Because my theory was the notary that signed the divorce decree for her should also be, they should be held liable as far as signing a notarized document that it wasn't signed in front of her and it wasn't even his signature. All the documents, the divorce decree packet has his signature is not on neither of the papers.
So you're going to need an attorney that can unravel this for you. You're not going to be able to do it yourself. And I can hear the frustration in your voice of what's already happened, but it's not going to get any better unless you get some help with this.
And is there a statute of limit? I know there's she waited a 3-year period because what the lawyer told us that why did we wait so long? And the thing is, whenever we got he gave me the packet, he's like, here, just put it away. That's the divorce paper. I don't have to worry about it. So I just got it, and I put it up in the safe where it was supposed to be with everything else. I put it away, and I left it there.
Yeah, if it's
when
been
we got the letter from the child support, I was like, what? And so we went through all the paperwork, and then I pulled out all the checks. I even went to our bank and pulled out the checks that we were paying her $200 a month. And the judge didn't even take that into consideration because some of the checks, she didn't want us to put her name on it, so we gave them to her like that. But on the bottom, where it says 4, I specifically put child support.
Yeah.
And he still didn't validate that.
All right. You need to have a judge, you need to have an attorney look at all of this and see if they can reopen the matter and make some adjustments based on the facts of what you've told me. But it's a fairly complicated...
We went through the child support office also to see if we could get it dropped, the amount.
Yeah, the only answer I can give you is you're going to need an attorney done. You've done everything you can yourself without a good result, so you need an attorney to try to unravel it for you. Okay.
Do you have one in mind?
I don't have one. I have a family law attorney on my staff, but she doesn't speak Spanish. So I think you're going to need somebody that you both can communicate with that's, can speak Spanish and English.
Okay. Now, I have power of attorney on him. Can I do it?
You can probably talk to the attorney, but the attorney's going to have to represent the husband.
Oh, okay.
So he's going to need to communicate with the husband, in my opinion.
Oh, okay.
All right, or both of you. All right?
All right, then. Thank you.
Bye-bye. Let's go to Carol, calling from Clearwater.
Yes, good morning.
Good morning.
Yes, I don't know if you can help me with this or not. This is in reference to a loan that my deceased husband had taken out back in, he passed away in 1992, 93, all right, and he had taken a loan out from New York State Higher Education, right, to pay for his daughter's tuition for college. He was having trouble making the payments, and he went to bankruptcy court, right, before he passed away, and there were 2 debts. One I paid after his death. I could not pay this one, okay, because I didn't have any money, and then I got sick myself. There was a co-signer on the loan, okay.
Who was the co-signer?
My husband's father. But he is long since deceased, I'm sure of that, They're both gone. And this is on my credit as a bankruptcy, and I want to get it off there, but I don't know if I'm legally responsible for this debt.
I don't think you are. If you
I need to know what the law is, because that's the only thing that's going to matter.
The law is that if you didn't contractually obligate yourself, as being a co-signer, for example, then...
No, I didn't sign for the loan, but I did go with him to bankruptcy, but that was dismissed because nobody was making any payments anymore, so it got dismissed. But it's still on my credit.
Well, ma'am, I'm trying to answer your question, though. The answer is if you didn't contractually obligate yourself on this loan, you're not responsible.
If I didn't, even if we were married at the time, I didn't sign anything.
You didn't sign anything. That means you didn't contractually obligate yourself. You're not automatically responsible for your deceased husband's loans or any other bills that related just to him without you obligating yourself.
Is there any way I could get some kind of find that in writing or something? I'm reluctant to call them and ask their legal department because, God forbid, if I am responsible, they could have been adding interest and penalties to this all these years. I don't have any way to pay it.
We have an attorney in our firm that can probably help you with this, so I can give you his phone number and extension if you like.
Well, I don't know if I can afford it.
Okay.
I had gone to recently to consumer credit counseling to see if I could get help that way. but I had to put this off for the time being because, frankly, I don't know what the law is. And in the end, that's the only thing that matters. And if they screw this up, I'm the one that's going to get hurt, not them.
The law is if you didn't contractually obligate yourself, you're not responsible.
Okay. All right. Well, I thank you for the information.
Yeah, I would go back to your consumer credit people and, work with them a little bit and see if they can help you get that off of your credit report.
Is there any statute of limitations on a loan like that? Because that's like you're borrowing from the government.
No, unfortunately, that's one of the few areas that don't carry a statute of limitations.
Yeah, like the IRS.
Yes.
Yeah,
no, those are the two. Those are the two ones you can't really escape from too much.
Right, because he takes trial chapter.
But I don't think you're responsible. So I really don't think that the statute would even apply to you because you're not responsible to begin with.
Okay. All right.
All right. Well, good luck.
All right, thank you very much. Bye-bye.
You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open for another 14 minutes or so. If you have a legal question, give us a call at 877-943-9673. That's 877-943-9673. And phone lines are open. We're here to help as many people as we possibly can. All you have to do is to dial that number. Oh, by the way, one of the things I really love to do in my practice is to go out in the community and speak my speaking engagements that I have. A couple of weeks ago, I got to speak at Indian Rocks Baptist Church on a Wednesday night. I've had multiple groups of all types, retirement groups, AARP groups, retirement clubs, I've spoken at several of the assisted living facilities, and if you have a need for a speaker, you have a coffee meeting once a week in your clubhouse, I'd love to come. All you have to do is ask me. There's no fee or anything. I come in, talk about a topic for 20 minutes or so, and then take your legal questions. It's just like the show, Ask an Attorney, all about Florida law. And if you'd like to arrange that, just call our office. I've done Kiwanis, Rotary clubs, women's clubs, men's clubs, New York, New Jersey clubs, you mentioned it. There's lots of clubs out there. Many of them do have speakers come in, talk about various topics, and then in my case, I just do an Ask an Attorney version of the show. But I just take a lot of times there are so many questions from the audience, I rarely have time to do my topic. But if you'd like to have me, I'd love to come. My office number for you to arrange that is 1-800-226-3529. So if you want to call and arrange a speaker, I would love to come. 1-800-226-3529. And if you're listening to my voice here, good chance that we have an office close to your area, and certainly would do my best to make myself available. Let's go to Rosemary in Bradenton. Hey, Rosemary.
Good morning. Good morning.
Good morning.
My granddaughter's husband is going to file for bankruptcy, and her name is on my house and also on my bank accounts. Will that affect her?
Well, she's not filing. Her husband is.
Well, she doesn't know whether she's going to go into it with him on it or what.
Well, whoever goes in on it has to have a complete list of their assets.
Well, would that include what I have, what she has her name on?
Well, she's a half owner, it sounds like, of whatever her name is on. So, yeah, they would have to be listed as assets.
Should I take her name off everything then before that happens?
Well, she needs to, if she's going to put her name on there, she needs to discuss that with the bankruptcy attorney, because you can't take her name off. She has to take her own name off as an owner.
Well, can she?
And that could trigger a look-back period of her shifting assets before filing for bankruptcy, which might not work either.
Okay, so she's better off if she doesn't go into it with him. As long as she don't go into the bankruptcy procedure with him, we're okay.
Yeah, but she wouldn't need to unless she's obligated herself on the debt they're trying to get rid of.
Oh, okay, I understand.
So if she's obligated herself on the debt, then she's stuck and might have to go through bankruptcy. But she needs to discuss with her bankruptcy attorney. She needs to be completely honest with the bankruptcy attorney and discuss her situation with her name being on some of your assets.
Yeah, because her husband don't know that her name's on anything that of my stuff, you know. What a mess.
What kind?
A mess.
Yeah. So tell her she needs to be extremely careful on that so she doesn't hurt you at all.
Okay, now I do have some of your, I'm going to contact your office. Your office is 1-800-226-3529.
Yes, ma'am.
Okay, I'm going to call and get an appointment.
Okay, great. Yeah, you probably would come to the Sun City Center office would be the closest one to you.
Okay, that'll be great.
All right.
Hey, and thank you for all you do. You're wonderful.
Well, thank you. Thanks for listening.
Great day.
Thank you. You too. Bye-bye.
Okay, bye-bye.
Let's go to Vicki in Apollo Beach.
Hi, good morning.
Hi, how are you?
Fine, thank you. I have a question.
Mm-hmm.
I want to do a will, but the situation is I have 2 children, and I have a son who does not speak to me for over 2 years, and my daughter feels that, you know, I should just write him off. But I would like to set some money back for him, and I was wondering if it's possible to do a trust that he has money at the time of his retirement, because I'm afraid he would blow it now.
Yes, you can definitely do that. The distribution plan of how you want to get money out to your children or anyone else can be set by you. So if you want to say he doesn't get the money till he's 60 or 65, whatever, and then even then it can be stretched out over per month or per year or per quarter.
Yeah, it wouldn't be that much because I don't have a big asset.
Yeah, no, you can definitely plan out the distribution.
Okay. Because I worry about him, and I don't like to totally write him off, but yet, everyone seems to think I do because I supported him a lot in the past.
Mm-hmm. Well, you can create a will or a trust for him, probably a trust if you want to do a stretch distribution to have monies held. And then if you change your mind along the way, you can always amend it. It's not like you did a permanent act or anything. You can always amend or change a will or a trust.
Okay. And I want to ask, is it a good idea to have one of your children on your checking account in case something would happen to you so that they could take care of your finances and so forth?
Well, I don't know if you were listening to the last question right before you, but if you put one of your children's names on your bank account and they get sued, divorced, have an accident, or bankruptcy, then your money's in jeopardy. So you put yourself in a position where you're liable for your children's debts that could affect your assets. So if you put one of your children's names on your assets and that child got sued, divorced, had an accident, or bankruptcy, then the creditors could come after that money because she would be a half owner of that account, at least, that you put her name on. So if you had a living trust, for example, then she could be the successor trustee. Being a trustee is not an owner, and the money could be used for your benefit if something happened to you, and then upon your death it would avoid probate. Upon your death, it would avoid probate because it's in the trust, and also that's the best way to maintain money in an account for a son that you don't want to give money to till he's 65. So trust would solve most of your problems, I think, and that you wouldn't be liable for your children's problems, and you can manage to have a plan to give money to your son when he's 65.
Okay. So it'd be better then, let me repeat this, take her off.
Mm-hmm.
And have a living trust in there giving her power of attorney over my finances.
Yeah, the trustee over your finances if something happens to you.
Okay. All right. That's what I want to make sure. Because, she's power of attorney over my house, but I want to get this will done.
Yeah. Just for information, I do have an office in Sun City Center. I've had a lot of clients from Apollo Beach. I had a little speaking engagement in one of the communities there. One of the gated communities had me come over and give a little talk So if I can be of further help, I'd be glad to.
Okay. All right. And all right, I'll give your office a call and set up an appointment then.
That'd be great.
Yeah.
All right.
Okay.
All right. Thanks so much.
Thank you. Bye-bye.
Bye-bye. All right. Let's talk to Susan in Clearwater.
Good morning, Joe, and thank you for all your help with different people's problems here.
Well, my pleasure.
Question. I heard or read that if, say, a father lives with a son for a period of 2 to 3 years, that there is not a look-back period for Medicaid. Is that true?
There is an exception to the normal rules that say if the son lived with the father and was the primary caregiver.
Yes.
Yes. Yeah, there is an exception to that rule.
Okay. And then when you speak about the spend-down period, does this situation of the caregiver, does that change the spend-down situation, too, with regard to Medicaid?
Well, let me answer it this way. So we have a Medicaid attorney, does nothing but Medicaid planning and VA planning. Okay. He also has a little book on VA benefits and how to get those too. But so basically, the way he can operate is there doesn't have to be a spend down. We can shift assets generally very quickly within like a 60-day window to qualify a person for Medicaid. And now he also does VA planning. But we can shift assets around to make them non-countable without having to spend all the way down to qualify. So one of the things that we use is what's called a personal service contract. So money can be transferred into a personal contract, which doesn't count as a transfer, doesn't trigger a look-back period. So you have X number of dollars in a personal service contract for your own care, and that wasn't a gift or a transfer that would disqualify you. So there are multiple options on how to do this without spending down. And that's what a good Medicaid VA attorney does. He's learned the art of shifting assets into non-countable categories, protecting them for the benefit of the person in need or in the nursing home, and maximizing what you can get in the way of government benefits.
Okay. Okay. All right. So, and that person is part of your office?
Yes. His name's John Frazier. So if you want to call the office, that would be, you're in Clearwater, so it's the local exchange, 586-3306, and his extension is 104, the direct line.
104. Okay. Very good. And
all right.
Thank you again.
Thank you. My pleasure. Bye-bye. Let's go to Mary in, all right, so Salt Lake City?
Yeah.
Wow. So you're listening on the computer?
Yeah, on my cell phone.
Cell phone. Cool.
Yeah, I have a place in Tampa, and I'm visiting here. And well, I heard the thing about if your kids are on your bank account, you might be responsible for.
Well, you're not responsible, but your money that you have their name on is in jeopardy.
Yeah.
It's not like they can sue you and take money that's just in your name. It's just the money that you have jointly with them is in jeopardy.
So, like I have mine on my account, and where I can put money in their account if they need gas or whatever, you know. And but my money that goes in is Social Security. My understanding is that can't be touched by anyone.
Yeah, in Florida, you're a Florida resident, right?
Yeah.
Well, exempt monies that creditors can't take, but this has really nothing to do with Medicaid planning. But a creditor can't sue you and take your homestead or retirement or annuities or life insurance or Social Security funds.
Or pensions? Or
pensions, you're right.
Yeah, okay.
Hey, listen, now I've show's over in 15 seconds, so I got to run.
All right.
All right, but thanks for calling.
All right. Bye-bye.
Thank you so much for listening to Ask an Attorney, all about Florida law. Remember, we're here every Saturday morning to help you, and if I can help you in any way, give us a call. Our toll-free office number is 1-800-226-3080. 3529. You have a great weekend. So long.